There is at present a trend in favour of making costs orders, including in needs cases, where a party has failed openly to negotiate reasonably and responsibly. In this talk, we are going to consider, in the context of this trend, the related issue of the treatment of a party's outstanding costs in a needs case. I will start the talk by considering recent changes to the costs rules and a series of first instance decisions at High Court judge level, where the court has considered how to treat the outstanding costs of the recipient of a needs award. Lucy will then explain the recent decision of the Court of Appeal in Azami, in which she and I appeared for the successful appellant. In Azami, as Lucy will explain, the Court of Appeal provided authoritative guidance on the proper approach to a party's outstanding costs in a needs case. The general rule in financial remedy proceedings is, of course, that the court will not make an order requiring one party to pay the costs of the other. But this has long been subject to the important exception that a costs order may be made when the court considers it appropriate to do so on the basis of one party's conduct before or during proceedings. The matters to which the court must have regard when considering whether to make a costs order are set out in Rule 28.3, paragraph 7, and include, by way of example, whether it was reasonable for a party to pursue a particular issue, the manner in which a party has pursued a particular issue, and the financial effect on the parties of any costs order. Further guidance is provided in Practice Direction 28A, and in 2019, in the wake of ongoing judicial concern about disproportionate costs, an increasingly influential and important amendment was made to paragraph 4.4 of that practice direction. The paragraph now provides that when considering whether a party's conduct justifies a costs order, the court will take a broad view and, quote, will generally conclude that to refuse openly to negotiate reasonably and responsibly will amount to conduct in respect of which the court will consider making an order for costs, including in a needs case where the applicant litigates unreasonably, resulting in the costs incurred by each party becoming disproportionate to the award made by the court. This change was supplemented in July last year by amendments to Part 9 of the rules, which now requires prospective cost estimates in Form H and open offers 21 days after the date of the FDR, unless the court directs otherwise. The increasing importance of this change and of making prompt and reasonable open offers is also evident in a series of recent decisions at High Court judge level, including the decision of Mr. Justice Mostyn in OG and AG, where he described the revised paragraph 4.4 as extremely important and added that, quote, it is important that I enunciate this principle loud and clear. If, once the financial landscape is clear, you do not openly negotiate reasonably, then you will likely suffer a penalty in costs. This applies whether the case is big or small, or whether it is being decided by reference to needs or sharing. Alongside these changes in the rules, there have been a series of cases in which the court has had to consider how to treat the outstanding costs of the recipient of a needs award. The situation is not uncommon. A spouse is awarded a lump sum for housing and/or income needs, but also has significant outstanding costs. If an additional lump sum is not ordered, the needs award is undermined. But if an additional lump sum is ordered, the court is, arguably, making a backdoor costs order with much less scrutiny than would be the case on an assessment of costs on the standard or even indemnity basis. The three most important decisions, pre-Azami, on this issue are WG and HG, Dagger and Banga, and MB and EB. And I will consider each of those in turn. The first, WG and HG, involved parties that met in 2004, married a few years later, and separated around 2015. There were 2 children of the marriage, and the parties had led an extravagant lifestyle. At the date of the final hearing, there were assets of about £12 million, which were largely non-matrimonial. The wife had incurred costs of £625,000, plus litigation loan interest and fees of £80,000. In turn, the husband had incurred costs of £426,000. Until late in the day, the wife had run a sharing case, but she eventually conceded that her award should be limited to her needs. The husband offered £2.4 million on a clean break basis. The wife sought £7.715 million. What makes this case important is that, having conceded that it was a needs case, the wife argued that in addition to the lump sum she sought, she was entitled to a full indemnity in respect of all of her costs on the basis that her costs were a debt that needed to be paid, and in a needs case, needs must be met. Mr. Justice Francis awarded the wife a Duxbury fund of £2 million and £1.65 million for housing. He then turned to consider the wife's outstanding costs and made four important points. First, people cannot litigate on the basis that they are bound to be reimbursed for their costs. The wife had chosen, in his words, to instruct one of the highest regarded and consequently one of the most expensive firms of solicitors in the country. Whilst I have no doubt that the representation has, at all times, been of the highest quality, no one enters litigation simply expecting a blank check. His second point was that, quote, "It might be said that I have assessed her needs at a given figure. If I have done that, then how can I leave her with a lower sum, which by definition does not meet her needs? This conundrum happens in so many cases. People who engage in litigation need to know that it has a cost." Third, he found that the wife's costs were excessive and that she had conducted her case in an unreasonable manner, including non-disclosure. Her open position was, quote, "completely unrealistic." The fourth point, however, is that Mr. Justice Francis said, "If I make no provision for the wife's costs or the litigation loan, then half of the Duxbury fund will be wiped out and she will be left with insufficient money to manage according to my assessment. Doing the best that I can to recognize that her costs are excessive, that she has presented an unreasonable case, but to recognize that her Duxbury fund cannot be completely undermined and that the husband's offer was too low, I'm going to add to the lump sum an additional £400,000, which is a little bit less than half of the total sum due. The wife would therefore have to find just over £500,000 in order to fund that part of the costs which I'm not ordering the husband to pay." The next case is Dagger and Banger. In Dagger, the court dismissed all claims by each party, having decided that the husband did not need to buy his own home and could remain in rented accommodation, as he and the wife had done throughout the marriage, and that he could afford from his own net annual income of about £130,000 to sustain into the foreseeable future a very good lifestyle, entirely comparable to that enjoyed during the marriage, without the need for any capital provision at all. The husband had debts, in this case, referable to costs, as a result of the litigation in which his unsuccessful claim was focused on two discretionary trusts, of which the wife was a beneficiary. An issue arose as to the husband's need to pay those debts, and Mr. Justice Holman declined to make any award. He concluded that, quote, "The husband simply does not have any objective, reasonable or justifiable need for 2.5 million, 1 million, or any other lump sum from the wife. His only pressing need is to clear his debts, but they are entirely referable to the costs which he has incurred in these proceedings. If I were to order her to pay to him a lump sum with which to pay off those debts, that would be tantamount to making an order for costs in his favor, which could not be justifiable." Dagger is the sole example of the court refusing to make any order in respect of a spouse's debts where they were entirely referable to costs, but it is also a readily distinguishable case from both these first instance decisions, WG and HG and MB and EB, but also Azami. And that's because the additional payment for the husband's debt did not or would not have the effect of undermining his ability to meet his housing needs. The final case, before I hand over to Lucy, is MB and EB. In this case, the parties had met in 1999 and married in 2000. The wife was a businesswoman from a wealthy family, worth about £50 million. The husband, in contrast, was a struggling artist with a long history of mental health issues. In an earlier decision, at the conclusion of a preliminary issue hearing, the court had made three key determinations. First, that the marital partnership had ended after about 4 years in 2004, although the parties remained in some form of relationship until 2016. Second, that save for a potential needs argument, there was no basis for vitiating a 2011 separation agreement, which provided that the husband, at his request, should have a flat in Brighton and a studio. And third, that there had been no marital request up to 2004 or subsequently. At the final hearing, it was the wife's primary case that the husband should receive nothing. But she had also made two open offers during the proceedings. First, about a year and a half before the final hearing, she had offered £300,000, which covered the husband's costs at the time and provided £125,000 of free capital. The husband did not respond to this offer. Second, about 3 months before the final hearing, she offered £336,000, which included £236,000 towards the husband's outstanding costs. The husband only replied a week before the final hearing, when he made his first open offer, seeking about £1.3 million. By then, he had incurred about £650,000 in costs in pursuing various claims, including that the marriage had lasted 17 years, that he had made a full contribution as a homemaker, and that he had a sharing claim in respect of a purported marital request. Of this total cost expenditure, £236,000 had already been paid by the wife pursuant to a legal services order charged against the husband's flat in Brighton. The husband had paid £36,000 and around £380,000 was outstanding, inclusive of interest. Mr. Justice Cohen concluded that the husband's position was way off the mark. He awarded a lump sum of £335,000 to meet the husband's needs and to enable him to acquire a car. He then considered the issue of the husband's outstanding costs. The husband argued that an additional payment should be made to cover the entirety of his costs, because otherwise he could not meet his needs as assessed by the court. Mr. Justice Cohen rejected this. He considered the new costs rules and referred to the amended Practice Direction 28A. He found that the total costs incurred were grossly disproportionate, and although the wife's offer was light, he was in no doubt that had the husband made a sensible offer, there would have been a quick resolution of the case. Further, he found that the husband had conducted the case irresponsibly and unreasonably, and was specifically critical of the late hour at which the husband made his first open offer. He awarded an additional £150,000 for the husband's costs, making a total award of £485,000. This left the husband in substantial debt to his solicitors, but Mr. Justice Cohen concluded this was a matter between him and them, and it was not for the wife to bankroll this litigation. But it is important to underline that notwithstanding the rhetoric in MB and EB and in WG and HG, and despite the relevant spouse in each case being significantly criticised for their approach, additional lump sums, significant additional lump sums, were nonetheless provided for them to meet their outstanding costs. Lucy will now explain Azami.
Thank you, Philip. So the case of Azami, it was a tricky case, and although it should have been relatively uncomplicated. At the date of the original hearing, the husband was 58, and he was unemployed, and he hadn't worked throughout the marriage. The wife was 55, and she was a barrister who specialised in immigration law and but mainly a property investor. Parties were both Iranian or of Iranian origin, and they'd met in March 2006. They fairly quickly had an Islamic ceremony later in 2006 and a civil marriage ceremony in March 2007. And they'd lived together from the date of the religious marriage. So it was therefore a marriage, including what was effectively cohabitation prior to the civil marriage, of 11 years. The wife ran an initial case that various members of her family were the beneficial owners of some of her properties. Eventually, she conceded the intervention and ended up paying the intervener's costs and the husband's costs. Lady Justice King referred to this as a pointless and ill-judged foray. She maintained at the final hearing that the court was concerned with a short marriage, but this wasn't, perhaps unsurprisingly, accepted by His Honour Judge Robinson, and indeed nor by Mr. Justice Cohen when he gave permission to appeal. He referred to it as a medium-length marriage in the permission to appeal. The parties have a son. At the time of the first instance hearing, he was about 5. And the husband said that he was his primary carer from birth until separation in December 17. And indeed, in the Children Act proceedings, the court had found that he had played a significant caring role for him. There'd been other proceedings between the parties. There were criminal proceedings in relation to a domestic assault by the husband on the wife. He was found not guilty in relation to those. There were Family Law Act proceedings and the Children Act proceedings regarding the child. And a fact-finding hearing in the Children Act proceedings was heard in December 2018. Where the Deputy District Judge found that the husband had assaulted the wife on 2 occasions, and that had led to the end of the relationship. There was a child arrangements order for the child with H, and he was to have direct contact initially in a contact centre, progressing to unsupervised or out of the contact centre, and on to stay in contact. The stay in contact was derailed somewhat by the pandemic, but contact was ongoing throughout all of the different stages of the proceedings. So the final hearing, first instance, came before His Honour Judge Robinson at the Central Family Court in early August of 2019, and he gave an ex tempore judgment late in the day on day 3. The husband's open position was that he was seeking a lump sum of $995,000 on a clean break basis to provide for his housing needs, debt repayment and some business setup costs. The wife's position, extraordinarily, was that the husband should receive nothing, except that she said she would forego a dowry that she said had a value of £676,000. It should be noted that she was saying that if he ever went back to Iran, he would be imprisoned permanently if it were found that he hadn't paid that dowry. The assets were largely agreed for the final hearing, and they were found to be about 1.8 million net of liabilities. And this comprised real property of about 2.3 million and some bank accounts and the parties' debts, which were significantly 257,000 or thereabouts for the husband and 300,000 for the wife. The husband's debts comprised largely legal fees, a litigation loan, a debt to his sister, outstanding Children Act costs, and outstanding financial remedy costs. Significantly, the debt to his sister she had borrowed commercially against her property, but that also comprised some living costs because he remained unemployed. So His Honour Judge Robinson gave the dowry no value whatsoever within the assets, and he ordered the wife to pay to the husband a lump sum of £625,000, so £625,000 out of about 1.8 million. And he said that this comprised a housing fund of £400,000, £25,000 for purchase costs and a car, and then £200,000 towards his debts, which, as I said, were £257,000. What His Honour Judge Robinson did was he deducted most of the costs for the criminal proceedings and most of the Children Act proceedings before he assessed the amount that he needed for his debts. And in his judgment, he said that he didn't think it was, he thought it was reasonable and realistic for the husband to have a home of his own. And that given the length of the marriage, it was unrealistic of the wife to say it should be treated as a short marriage. Effectively, she was saying he should have what he put in, which was she put at nothing. Just imagine if a husband said that of a wife who had played a significant caring role during the marriage for the child. His Honour Judge Robinson said that he couldn't understand how this could be said to not provide him with an entitlement to have his needs considered. And he said, I rhetorically ask on a gender neutral basis, what would be the case if the gender roles were reversed? He said that the property particulars were unhelpful on both sides, and that the ones that put forward by the wife were below the standard she could have expected her son to stay in. And on that basis, he awarded the £425,000 for housing needs and a car and costs. And he said that would give him something a bit more than basic accommodation in an area local to where the parties had lived, which was entirely appropriate. He also said, though, in addition, the husband needed to deal with his debts. And he said that he recognised my argument that if he didn't provide for those debts, that he wasn't dealing with his needs. And he said, although his costs of these proceedings are greater than hers, there is some reason for that, and I'm not going to deal with that in a mathematical way, presumably referring to the ill-judged foray with the interveners. But we had argued throughout, even at first instance, that the wife's litigation misconduct, I mean, it was appalling, we said. But as I said, the judge did not take that into account because he was prepared to provide for most of his debts. So he said he would award him the sum of £200,000 going towards his costs. It would go a long way to pay his litigation loan and pay off his sister. And then he had to decide what he did with the balance of the money between his housing and the payment of soft debts. He said that's a matter for his sister. The wife then appealed, and she appealed on the basis that it was wrong to include the payment of costs in financial remedy proceedings where there was no basis for an order for costs. It was wrong to include a payment of his costs in Children Act and criminal proceedings where there had been no orders for costs made in those proceedings, and also that it was wrong to find that he required owner-occupied accommodation. So that appeal notice came before Mr. Justice Cohen, and he made the standard directions for a bundle and transcript. And then he ordered my client to file a reply and for a matter to go back before him for some further directions. A reply was settled and filed on behalf of the husband. But unfortunately, without having sight of the reply, Mr. Justice Cohen gave permission to the wife to appeal on all three grounds, but noted that the analysis put forward by the wife of the cost regime does not seem to me to be helpful. And he directed some more property particulars in the bracket of £250,000 to £425,000. Once it was drawn to Mr. Justice Cohen's attention that he'd not taken into account the husband's reply, he considered the matter afresh, and he directed that the matter wouldn't be heard before him, just in case there was any suggestion of bias. But what he said was, my decision remains as before for the reasons already given. I would add only that no consideration seems to have been given to some of the respondent's costs being a charge on his new property. Now, this was the first time charge had been mentioned by anybody. And of course, it became relevant later on in the day, once the matter came before Mrs. Justice Judd for appeal, which it did in May 2020. The wife was represented by different counsel on that occasion, but the husband was by then acting in person. And it was of course, we were just in the middle of the first lockdown. Mrs. Justice Judd considered that the assessment of £400,000 for a property was correct, and that £25,000 for the costs and a car was also perfectly within the discretion of the first instance judge. But she concluded that there was force in the point that the wife made about the issue as to his debt, and decided that his decision as to the award of £200,000 to pay the costs could not stand in its current form. She thereafter decided to exercise her own discretion, and she imposed a charge of £200,000 on the prospective property in the wife's favour, to be triggered by the husband's death, his remarriage, or his permanent cohabitation. After the draft judgment was handed down by Mrs. Justice Judd, both parties sent in further submissions. And on behalf of the wife, it was sought for there to be further reasons in respect of the charge, because the wife hadn't addressed the court on the question of whether or not she should have a charge. She said it wasn't the outcome she sought in any event, and she wasn't indeed invited to address the court on charge. And in the annex to her judgment, Mrs. Justice Judd said that she considered the judge was wrong to award the husband the lion's share of his costs. And she said, particularly in circumstances where in the Children Act proceedings, the district judge had found that he had assaulted the wife on 2 occasions. Of course, His Honour Judge Robinson is a circuit judge. And she said that she didn't consider it would be a fair outcome for the wife's charge to remain if the husband remarried or cohabited. She said, ideally, that given the level of the acrimony, there should be a separation of the parties' finances, but it wasn't an easy outcome. She said whether or not someone's married or cohabiting is an easy thing to determine, which I find quite extraordinary. I mean, remarriage, yes, but cohabitation, not always. And she said if the husband cohabits or marries someone with little or no financial means, it would not render him homeless, although he might have to seek a cheaper property. She then made an order for costs against the husband in the sum of £25,000, which she added to the charge on the basis that the wife had partly succeeded in her appeal. And so the total charge became £225,000 on a property that was expected to cost no more than £400,000. And it also it has to be borne in mind that at the appeal, the wife had once again run a case that the husband should get nothing. So we came back in, this team, Philip and I, instructed by Charlotte Connor at Dawson, Cornwall, for the second appeal. And of course, the first thing we had to consider was in relation to whether you can get permission on a second appeal, because it's difficult. So just to reiterate the grounds when you can get a second appeal, it's where a decision being appealed is itself an appeal. It's within the meaning of a Section 55 of the Access to Justice Act. It can only be made to the Court of Appeal. It's not family proceedings for the purpose of the FPR. So these appeals are governed by Part 52 of the Civil Procedure Rules and PD 52C, and permission is required. And that permission is dealt with by the Court of Appeal on paper, save where a judge considering the application directs that the application is determined at an oral hearing. That's not what happened in this case. Lady Justice King, I think it was, determined that permission to appeal should be given on paper. And in fact, very late in the day, the wife cross-appealed and Lady Justice King gave permission for that cross-appeal, presumably because it was all the same issues that were going to be determined. The Court of Appeal won't give permission on a second appeal unless it considers that the appeal has a real prospect of success. It raises an important point of principle or practice, or there's some other compelling reason for the Court of Appeal to hear it. In Azami, we said that permission should be given because it had a real prospect of success, and it raised this important point of principle concerning the payment of debts referable to costs in needs cases, which we said hadn't been considered by the Court of Appeal. We also said there was compelling reasons because Mrs. Justice Judd was wrong to interfere with His Honour Judge Robinson's decision in the absence of any error, especially where that interference undermined, we said, the core purposes of his award. We also said that the charge that neither party had sought was manifestly unjust. So our grounds of appeal said that Mrs. Justice Judd was wrong to overturn the decision because what she had said was, well, there was no order for costs in the Children Act proceedings. The judge had put the wife in a worse position than if he'd made a cost order against her because, of course, the wife was saying giving him all that money towards his costs was effectively an indemnity cost order. Mrs. Justice Judd said he was wrong because he allowed the husband to recover the lion's share of his costs. She said he didn't really explain why he made the decision. He didn't really take into account the wife having to pay her own substantial bills. And she said, particularly where the husband had been found to have assaulted the wife on 2 occasions. And then she said that he should have balanced the decision he'd come to as to the reasonable needs for a property as against his responsibility to meet his own costs for the litigation that he'd been involved in. We said none of these matters entitled Mrs. Justice Judd on the facts of this case to say that his decision was wrong and to then exercise her own discretion and impose a charge that nobody had asked for on the husband's prospective home. We said that it wasn't open to her to interfere with his decision to award him an outright sum of £200,000 towards his debt, unless it fell outside the generous ambit of his legitimate discretion. And we quoted Mr. Justice Moore in WD and HD when he said it's highly unlikely that 2 different judges will exercise their discretion in identical ways. Doesn't mean one of them's wrong. And we said that there was a particular need for Mrs. Justice Judd to be cautious when deciding whether to interfere with that first instance decision, because His Honour Judge Robinson had an almost unbounded discretion, and because it was an extempore judgment late in the day, on the final day, and we quoted the well-known passage from Piglovska, the one that says, you know, the exigencies of daily courtroom life are such that reasons for judgment will always be capable of having been better expressed. An appellate court should resist the temptation to subvert the principle that they should not substitute their own discretion for that of the judge by a narrow textual analysis which enables them to claim that he misdirected himself. We said emphatically that the mere fact that the husband's debts were referable in the main to his costs of these different proceedings is not an established or justified restriction on the exercise of the discretion that was afforded to His Honour Judge Robinson. Indeed, we said it's entirely conventional for judges up and down the country at every level to award payments for debts referable to costs in needs cases under the Matrimonial Causes Act, and of course we see it in the Schedule 1 cases as well. So the decision by the Court of Appeal, the lead judgment was given by Lady Justice King, with whom Lord Justice Moylan and Lord Justice Newey agreed. She started off by saying it was a straightforward financial remedy case. And she quoted His Honour Judge Robinson, who said it was marked by extreme positions and degree of bitterness, although she thought that His Honour Judge Robinson had understated that position. The issue that the Court of Appeal, perhaps not surprisingly, was most interested in was the appropriate treatment of the outstanding costs incurred by the recipient of a needs award. And so, having quoted the 3 cases that Phillips referred to and set out, this is what she said. She took those 3 cases, so Mr. Justice Francis in WG and HG, Mr. Justice Holman in Dagger and Bangor, and Mr. Justice Cohen in MB and EB. And she said, all these cases turn on their own individual facts. And the most significant principle to be drawn from them, either individually or collectively, is that the judge at first instance has a wide discretion as to the extent to which it's appropriate to order an enhanced lump sum, as was happened in Nizami, to a party in receipt of a needs award designed wholly or in part to satisfy their outstanding cost bills. In relation to WG and HG, the decision of Mr. Justice Francis, Lady Justice King said that this was a case where the wife, who was the receiving party, had adopted a wholly unrealistic open position and whose costs were excessive. And she said the judge's decision must be seen in context. First and foremost, Mr. Justice Francis had held that she'd incurred a substantial part of the costs unreasonably. And Lady Justice King said, which was not the case in the present appeal. That's not something that was said about Mr. Azami. The judge, notwithstanding that that was the case, Mr. Justice Francis, nevertheless gave her a lump sum of £400,000 in addition to that required for her assessed needs. So in other words, even when somebody had behaved badly and a finding had been made to that extent, she still got an extra 400,000, albeit that didn't satisfy all of her costs. But what Lady Justice King said was it should be understood that this was in the context of a case where the wife was receiving a mortgage-free property of 1.65 million and a Duxbury fund of 2 million. Which was to produce an income of life for £90,000. So context is everything. Mr. Justice Cohen in MB and EB took the view that the case should have been easy to settle, as Philip set out earlier, and Lady Justice King restated that. And she said that only his income needs remained to be satisfied, which was done on the basis of £25,000 per annum for life, which converted into a Duxbury figure of £325,000. But in order to get this amount, the husband had spent £650,000 on costs, of which the wife had already paid 236. Mr. Justice Cohen had concluded that those costs were unreasonably incurred. But even in that case, Mr. Justice Cohen still gave the husband an additional £150,000. And even where, just like in the previous case of WG, there was litigation misconduct, even in those cases, the parties who had done so got some of their costs paid. And then in relation to Dagger and Bangor, Mr. Justice Holman in Dagger and Bangor, the other side considered this their trump card, both before Mrs. Justice Judd in the High Court appeal and before the Court of Appeal, because of course in that case, the husband didn't get anything towards his cost. And what Lady Justice King said about that is Dagger, from which Miss Phipps seeks comfort, is the only case brought to the attention of the court where the court refused to make any order in respect of the husband's debts, which debts were entirely referable to costs. In Dagger, Holman J dismissed all claims, but Holman J said that the parties having chosen to live throughout their married life in rented accommodation, the husband did not need to buy his own home, and that on his net income of £130,000 per annum, he could afford to sustain a very good lifestyle, entirely comparable to that which the parties had enjoyed during the marriage, without the need for capital provision. And so she went on to say and to conclude, significantly, in none of these cases, and this is part of the takeaway from the Azami case, in none of these cases would the recipient's security of accommodation have been jeopardised as a result of the order made by the court. So that's paragraph 59 of the Court of Appeal judgment. Dagger was a very unusual case on its facts. In my judgment, of more assistance in considering the approach taken to this issue in the few reported cases is the fact that in WG and HG and MB and EB, notwithstanding the fact that the recipient had acted unreasonably and run up wholly unjustified costs, the court nevertheless awarded an additional sum in order to ameliorate the impact of costs on their needs award. And in neither case were the housing needs of the receiving party put at risk. So in other words, with how much more force would it apply to a case like Azami, where the housing of a party with a young child of primary school age could be put at risk. So what's the guidance? Well, it's perhaps a little curious, the guidance. What Lady Justice King said is that there's a wide discretion of the judge to determine the extent of a party's needs and the extent to which they should be met. Well, we know that. She said, having said that, in my judgment, in cases where it's argued that an order substantially in excess of the sum required to meet a party's assessed needs is sought in order to settle outstanding costs or debts referable to costs of that party, the judge should consider whether in any event the case is one where consideration should be given as to the making of an order for costs under FPR 28, 6 and 7. So that's your litigation misconduct, in particular by reference to PD 28, para 44. And I shall remind you what that part of what that says. So PD 28, para 44 says, in considering the conduct of the parties for the purposes of Rule 28, 3, 6 and 7, including any open offers to settle, the court will have regard to the obligation of the parties to help the court to further the overriding objective, and will take into account the nature of importance and complexity of the issues in the case. Then a bit further down says that the court will take a broad view of conduct for the purposes of this rule and will generally conclude that to refuse to openly negotiate reasonably and responsibly will amount to conduct, in respect of which the court will consider making an order for costs. This includes in a needs case where the applicant litigates unreasonably, resulting in the costs incurred by each party becoming disproportionate to the award made by the court. Well, of course, there was a finding that both parties had pitched their cases too high or too low, but certainly, and I'm bound to say this, having represented Mr. Azami, I think a position where not only at first instance, but at the appeal, the first appeal, where a party says after an 11-year marriage with a child, one party should get nothing, has to have been a case where, had I applied for costs, I could have succeeded. And the reason I didn't apply at first instance was because His Honour Judge Robinson had made an order covering most of my client's debts. And that was one of our grounds for appeal, was that my client was prejudiced because he had missed his opportunity. So that should be borne in mind. So what Lady Justice King goes on to say is that whilst not carrying out a full costs analysis, the judge should have firmly in mind what the order which they propose to make by way of an additional lump sum to meet a party's costs would represent if expressed in terms of an order for costs. To do this would act as a cross-check of the fairness of the proposed order. So in other words, whilst the judge at first instance is hearing the case and considering his or her judgment, he's got to be thinking, right, well, if I give them their costs, how much would that mean? What would it be if I made an order for costs? I think this is a big ask of the jobbing judges, most of whom are district judges up and down the country, who deal with the needs cases. She went on to say that it was argued on behalf of the wife that it was the judge at first instance approached it, that which would have been made had an order for costs been made on an indemnity basis, and that was unfair, and that some lesser amount should have been awarded to partially cover his debts. But Lady Justice King said, in my judgment, the fact that the proposed award might on the facts of a case amount to the equivalent of an indemnity costs award may be a powerful argument and is undoubtedly a matter which the judge should take into consideration, but it is not a cap on the judge's discretionary power to make such award as he or she determines will meet the needs of one of the parties. So you don't have to worry about the indemnity costs point, which they had run from the word go. In fact, they were even running it at first instance. And Lady Justice King's conclusion: the judge was entitled to award the husband a sum towards his debts, particularly in circumstances where, unlike WG and HG and Dagger, the husband's litigation conduct was not criticised, the level of his costs was not criticised, and he needed substantially to clear his debts in order to meet his basic housing needs. So that's a very nice summary. So what is ultimately the takeaway from this? Well, it's relatively simple, although perhaps not as simple in practice. In needs cases, the lawyers for the client with the needs case has got to be aware from the off about litigation misconduct. So the client's got to know that it's important to meet deadlines. The client's got to know, even though no doubt we all say this till we're blue in the face, the importance of proper disclosure. And I'm not just referring to non-disclosure. Sometimes there's just shoddy disclosure. The client's got to know that they cannot take an unreasonable position. You know, Philip outlined earlier the new rules in relation to open positions, but open negotiating is now very, very important. And we've all got to try and throw off the shackles of, you know, having in our back pocket a without prejudice that's slightly better. We've just got to bite the bullet and negotiate openly and reasonably. But also, in addition to that, avoiding the pitfalls of litigation misconduct, it's about keeping costs down so that there can't be any criticism of the bill, even if it can't be said that there's litigation misconduct, that one party can't say, well, he or she shouldn't have spent that much or had those expensive lawyers or whatever. So that's really it for Azami. It's a neat little point. Some people might say it's perhaps what we all knew all along, but it's nice to have the Court of Appeal saying it. So thank you for listening to our lecture.